Yes. Okay, so welcome everybody to our webinar. Is that me? Yeah. Well, welcome everybody to our webinar. And today we are going to engage with energy transition mining disputes because there's a lot of mining disputes, mining related issues arising out of particularly the African continent. And we do know that for the energy transition, the mining industry is particularly important. For climate change, the mining industry is equally important. And so we have Hafsa, who does public international law. She's with Queen Emmanuel. So she's going to guide our discussion this afternoon. She's moderating for us. Hafsa, we're so grateful. Thank you so very much for accepting our invitation. And our speaker is somebody that is very, very well known to the community. And that's, incidentally, he's my Nigerian brother. I have to claim him to start with. And he's also, thank you very much for that hand clap. And he's also a senior advocate of Nigeria. So we're both barristers out of Nigeria. But he's a senior person. Me, I'm just tagging along, and that's okay. And Prof, he's also a full professor at Hamad bin Khalifa University out of Doha. But the work of Prof that he's actually been engaging a lot on is his role as the UNESCO chair on environmental law and climate change, sustainable development. He engages with these issues. So we do have an excellent pair that would engage with this conversation with us. Hafsa, can I hand over to you? And as we agreed, you will take over and then I'll come back later.
Thank you so much, Emile. I mean, the first thing I have to say very quickly is that I'm also Nigerian, and so we have I have a sister and a brother on this call. So that's fantastic to have a session with 3 Nigerians right at the front. I'm very honored, so thank you very much for inviting me. I don't have too much to add to what Emilio has already said in terms of background, just by very, very brief explanation of who exactly I am. And I've been working in public international law and international arbitration for just over a decade. I made partner at Queen Emmanuel last year, and you know, I basically have a very strong and keen interest and particular experience in the continent and also the Middle East. So, you know, Professor Olawuyi is like the perfect person for me to engage with on this, because he also has the same crossover with Africa and the Middle East. I think there's only one point that I would like to sort of raise before I sort of hand over to him to give a short presentation, and then we'll get into a Q&A, hopefully with as many members of the audience as possible. You can sort of raise your hand, and I think Emilio will facilitate, or perhaps you can come on and actually speak as well. I've also got a few questions as well for Professor. The only thing I wanted to mention that I hopefully Emilio can pop into the chat is that Professor has published a book called Environmental Law in Arab States. And it's just a very interesting book because it's the first of its kind. There's not sort of been a book length exposition of these topics. And it won in 2023 the American Society of International Law's book prize. So that is, you know, something that I thought was worth raising before we sort of get into this. And hopefully that's something that people can have a little click on when it comes around in the link. So with that sort of brief introduction, I'll hand over to Professor to give the presentation.
Thank you very much for the very kind and warm welcome and introduction, Hafsa. It's my great pleasure to be here today and to participate in this important session organized by the SOAS SADRC Center for Dispute Resolution, which is, of course, ably led by Professor Emilia Onyema. I think if Professor Onyema describes you as great and senior, then you know you have succeeded in this profession, because because she is indeed one of the most revered and highly respected arbitrators, and we're very, very proud of the great work that she's been doing and her leadership in this area. And of course, I think Hafsa never mentioned to me a Nigerian connection in all our correspondences. So maybe it was meant to be a secret, a surprise. So, but I'm really, really proud, of the great work that you've been doing, Hafsa, in practice as well as in the area of dispute resolution. I thought I will just introduce this topic a little bit, because there is a tendency for lawyers to do two things. Number one, we assume that arbitration ADR is only for lawyers. And I get reminded every time that we actually have engineers that are arbitrators, so that's one thing we often assume. The second thing we assume at times is that the whole discourse on energy transition mining is known to everyone. So in order not to fall into that second assumption, I will introduce these key topics then such that when we move along in the discussion, then everyone on the call will be on the same page. But of course, I know to some, my preliminary introductory words will be too familiar. So please just indulge and pardon us as we try to carry everyone along. Of course, the energy transition has become one of the key issues of our time. Over the years, our countries and societies have depended on oil and gas as bedrock for the economy. I'm from Nigeria. I do a lot of work in Qatar as well as across the Middle East, economies that are typically supported by oil and gas revenue. And as a counsel to many governments, when I mention the word transition, it's either I get transition to what and why should we transition? But of course, it's the reality of our time that energy transition is rapidly evolving. And as it is evolving, disputes are also coming up, either disputes relating to the subject matter of transition itself or how the transition process is evolving. So some of the things I would say are in our book. I know Hafsa mentioned my book on environmental law in Arab states, but this book, the Palgrave Handbook of Arbitration, myself and Victoria Nabile sort of began to X-ray and document the changes that are emerging as a result of energy transition and the implications for dispute resolution. So some of the things I would say are there in case you are interested in reading more about this. And like I said, traditionally, we've had the extractive sector, petroleum, natural gas, and mining. And then we've had the non-extractives, mainly natural resource development that has nothing to do with drilling and extraction. But now we are seeing with the energy transition as a result of efforts across the world to combat climate change, we are seeing the rise of a renewable energy industry across the world. There's almost no country today that does not have either a regulation or a guideline on the integration of renewable energy into the national electricity system. We are also seeing the rapid development of what we call distributed energy resources, solar panels and the likes across the world as a result of this ongoing energy transition aimed at minimizing the emission of greenhouse gases that cause climate change. And of course, whenever we talk about climate change, the oil and gas industry is often seen as a lead cause of this problem. So the energy transition is taking place, and the renewable energy industry is rapidly developing. And like I said, as this transition is ongoing, a number of disputes are emerging. And I'm going to talk about 2 or 3 hot trends or hot topics, the sort of disputes that we're seeing these days. More than 2,000 jurisdictions, and that would include local governments and councils across the world, have declared a climate emergency, meaning that they either have a bylaw, a legislation, a charter talking about climate change. For example, Nigeria has a Climate Change Act, which establishes guidelines on what companies should do with respect to climate change. But as a result of this emerging legislation, you're then seeing a rise in disputes as well. And it's majorly maybe a new law that is saying you should reduce your production or the production you could have been able to do under your license, and the license holder saying, well, when you gave me this 30-year license, you did not tell me anything about climate change. So why are you telling me to reduce production? Then that's a breach of contract. So we've seen a number of disputes on this. For example, challenge to government their measures to reduce or phase out extractive operations, whether and with license holders trying to evoke the stabilization provision. As you know, a stabilization provision is typically a provision or a clause in a contract that says, well, as we sign today, you will not change the law, and if you change the law, you may have to restore me back to an economic equilibrium position. So you've seen a number of oil and gas companies trying to rely on stabilization provisions to challenge measures to phase out extractive operations as a result of the energy transition. And so we've seen a rise in investor state arbitration relating to that subject. Even issues relating to the use of incentives to promote renewable energy. You've seen a number of stakeholders, especially oil and gas majors, challenging the introduction of renewable incentives, because of course that affects the marketability of oil and gas products, right? I've been involved also in dispute relating to efforts to phase out the use of plastics, and you've seen oil and gas majors challenging that as because you say, what is the business between oil and gas and plastics? Well, plastic is made from petrochemicals. So if you say people should stop using plastics, you're basically saying people should, you are basically saying the petrochemical industry should shut down. So there have been disputes as well relating to that. There have been disputes relating to changes in market and electricity transmission rules, especially efforts to integrate distributed energy resources, like I mentioned, into the electricity grids, and we've seen traditional electricity systems challenging that. Of course, greenwashing is another one, and that is often the big issue, whereby businesses, in response to climate legislation, businesses are releasing well-printed sustainability reports saying that they are environmentally friendly or sustainable, or their product is green or something, which turns out not to be the case. And we've seen a rise in dispute relating to that. Also, issues of management committees, efforts to integrate ESG competent boards into the mix may be challenged as well. And these are examples. Some of them are have been arbitrated upon. Some of them are, for example, the Westmoreland case in Canada, a classic example whereby the government of Alberta had introduced a legislation to phase out coal-generated electricity by 2030. And of course, the license holder challenged that, stating that it was an expropriation of their investment in coal. Of course, this was dismissed for lack of jurisdiction. There is the case, brought by RWE against the Kingdom of Netherlands, again, almost very similar to the Canadian one, seeking 1.4 billion euros in compensation for what they described as expropriation of their investment. Again, due to the introduction of legislation relating to energy transition. The renewable energy case in Argentina, more than 50 investment treaty arbitrations against Spain alone under the Energy Charter, and the like. So I think the bottom line is that the introduction of legislation on energy transition or climate change is increasingly seen by license holders as sort of contradictory to their rights under existing petroleum licenses. And that is a question that I think we're just about to start seeing. There will be a lot more to come. And so arbitrators would have their hands full with these sort of challenges going forward. A second trend is business and human rights. And this is, as Professor Yema mentioned, an area that I've been working on for a while. As you may already know, I'm a member of the UN Working Group on Business and Human Rights. I currently serve as chairperson of that working group, and it's a working group mandated by the Human Rights Council to promote the dissemination of the UN Guiding Principles, UNGPs as we call it, and that's the document on your screen. The UNGPs was adopted in 2011 as part of global efforts to mainstream or recognize the responsibilities of businesses. Before now, whenever we talked about human rights, we would say this is what government should do that. But I think since the time of Kofi Annan as Secretary General, he began to commission reports and studies on can businesses do more when it comes to human rights. And you will recall that Professor John Ruggie led a comprehensive report on this subject, and that report eventually became adopted as the UNGPs. So since 2011, and of course, as part of that adoption, a working group made up of 5 experts, one from each world region, was established to be at the forefront of promoting the dissemination and implementation of the report. And that's the working group that I currently chair. As a result of the UNGPs, countries have introduced legislation and NAPs meaning National Action Plan on Business and Human Rights, highlighting the responsibility of businesses to integrate human rights across their value chains. And you have many countries releasing such legislation. France, duty of vigilance law. We have the EU Corporate Sustainability Due Diligence Directive, CSDDD, and I need 2 hours to talk about only that one. You have the UK Modern Slavery Act, the German Supply Chain Act, and even in Africa, you have National Action Plan on Business and Human Rights, Ghana being the latest to introduce one, Liberia in 2024, Nigeria in 2023, Uganda 2021, and of course, Kenya being the early mover in this area. So these NAPs and legislation, what do they basically say? Businesses have responsibility to ensure there is no child labor, no modern slavery, no greenwashing in their value chains. And with such legislation, then there of course, there will be disputes relating to, is my business complying or are they in violation? And we've seen a rise in this dispute. Before I move on to give examples, the UNGPs itself has 3 pillars. The state duty to protect, so the state must enact legislation that implements the UNGPs. The businesses themselves must respect human rights by adopting policies, corporate statements and policies and guidelines internally to ensure that human rights is integrated across their value chains. And the 3rd pillar is access to remedy, the use of judicial and non-judicial mechanisms to ensure that whenever there is a wrong, a human right wrong in business context, then there is a remedy. And it is in this 3rd pillar that the role of arbitration and ADR is important. Whenever I have a problem, maybe an oil and gas company is implementing a project and is affecting human rights, what remedy should I get? Traditionally, we go to court, but because we know that there have been delays associated with litigation in many contexts, in many countries, I've been involved in litigation that I was told started even before I was born, related to oil and gas, So it's obvious that there is indeed a need for other mechanisms, and that's why the UNGPs indeed recognize the need for non-state judicial mechanisms, which will include arbitration, conciliation, mediation, as ways to ensure that the UNGPs provide, are robustly implemented, and that whenever there is a human rights violation, there is indeed a remedy. So it is crystal clear that ADR falls within the 3rd pillar of the UNGPs and will be very useful going forward. And we've seen this being taken up. These are examples. Just recently, Bile and Ogale communities, that case, which, again, will now proceed to full trial in 2027. But the UK court noted that there is indeed a continued liability doctrine, and that a company can be sued for pollution even if it occurred many years ago. Because I believe there was an attempt by Shell to argue that this occurred many years ago. So now the court says it could go to trial based on the continued liability doctrine. And there are a number of other business-related cases, issues of forced labor and supply chain liability, issues of greenwashing. And this is a recent example as well, in which This food company was sued by the Attorney General of New York on behalf of New York for their claim about their food product being green and sustainable, and that resulted in a 1.5 million settlement. This, of course, some of these are court cases and they are litigated. So, but they show you examples of claims that could arise out of business responsibility for human rights, whether it is the Lafarge case on corporate complicity in conflict and war crime situations, and a wide range of them. And the key question one would ask is that why are these all in court? Why are we not, since I mentioned earlier on that Pillar 3 actually talks about ADR, then why is it that these cases are being taken to court rather than us using arbitration to resolve them? And I'm going to give my thoughts on some of these, but I will talk about the third trend first. Of course, like I mentioned, I do a lot of work in Africa and the Middle East, and one of the key issues coming up these days is the issue of decommissioning. As we know, oil and gas licenses are often for 25 to 30 years. And at times, at the end of 30 years, you realize that maybe the field is no longer viable and it's no longer producing. So there's a need to decommission. Decommissioning simply meaning, closing a field at the end of its valuable life. But of course, there have always been environmental issues arising from decommissioning. And now studies show that by the year 2038, more than 1,000 structures and 6,000 wells in the MENA region will be more than 30 years old and will be ready for decommissioning. And so there's the issue of who is going to be responsible for the cost of decommissioning. Is it the license holder? Is it the license holder that originally got the license, or the current license holder? You would think these are elementary issues that, of course, but of course, we saw in this recent case in the UK, it became an issue in which a company was arguing that, well, the liability for decommissioning should be with the previous license holder, not with the recent license holder. And that became a question, and which got me thinking that when we then have more than 1,000 structures and 6,000 wells, coming up in Africa and the Middle East, then there will be a lot of questions on decommissioning liability, decommissioning obligation. Has it been transferred with the transfer of licenses? Given that the decommissioning plan is often originally filed by the person or the company that got the license from government. So does government recognize the transfer of license to mean the transfer of decommissioning liability or obligation as well? Well, I asked the question, and I'm going to wrap up on this point. Why is arbitration not still really used, especially when it comes to business and human rights, or when it comes to greenwashing, modern slavery, child labor? The first question is, does the arbitration agreement include a clause on the use of, does the agreement, rather, like the mining agreement, the, production sharing contract, the concession, the sort of things we use in the oil and gas industry, does it clearly include an arbitration clause that would allow you to use it to resolve disputes relating to child labor, for example? And if the answer is no, then it becomes difficult. And that's why the role of lawyers drafting this agreement will be very crucial. As we all know, arbitration is based on party autonomy, it's based on party agreement, right? If there is really no arbitration provision, it will be very, very difficult, even for the most sophisticated lawyer, to argue that we could use arbitration. So that would be the first. The second is, in our studies, we've also seen a number of archaic laws that continue to limit the use of arbitration to just commercial disputes. And the sort of disputes we're talking about when it comes to mining, business and human rights, at times energy transition, are supply chain disputes that may not be commercial in nature, land disputes, lack of public participation, lack of public information. These are not commercial disputes, right? A community arguing that their land has been confiscated. So we then ask the question, why do we still have laws that limit the use of arbitration and ADR to only commercial disputes? And that's an area. And when I said in Pillar 1, there is a state duty. So that's why we often have meetings with governments saying, perhaps you need to review your laws to expand the use of ADR to non-commercial disputes as well. And we say that it is a failure on behalf of states. It's a failure in Pillar 1 if a state is not really, in my view, if a state is not really reviewing its arbitration laws to expand it to non-commercial dispute, then it might be a significant failure to uphold Pillar 1 of the UNGPs. And there is the issue of, even if we were to use arbitration, what rules apply? There are efforts in this regard, and I say, the Hague Rules on Business and Human Rights Arbitration is one, effort that has been well received, launched some years back, which clarifies how arbitration could actually be used in the context of, business and human rights disputes, especially dispute between local communities and corporations. Again, there is now a need for stakeholders to integrate these rules, especially the Hague Rules, when drafting contracts, such that there is clarity that if there is a non-commercial dispute, then it could be resolved using arbitration and ADR, and this would be the applicable rule in that regard. So I would say there is a need to engage with these initiatives because, when I look at my work in the UN Working Group, our ultimate goal really is to ensure that whenever there is a wrong, there is a remedy. Whether that remedy comes from litigation or comes from arbitration, it is not as important to us. What is important is that whenever there is a wrong, there is a remedy. So I think we all know the downsides of litigation. We all know the challenges that stakeholders are faced with litigation. I've talked about delay. I've talked about issues of confidentiality in terms of business relationship. I've talked about some of the challenges that litigation has traditionally faced. So if access can come through arbitration, then we encourage stakeholders to clearly integrate this sort of initiatives that try to integrate mainstream the use of ADR and arbitration in business and human rights disputes. There is also a need to signpost arbitration and ADR, especially when negotiating impact benefit agreements with local communities or in B2C contracts. Because one of the challenges we get is that you negotiate an impact benefit agreement with local communities, and they say, well, we were not even now. It was in fine print that arbitration and ADR would be used, and we were never aware. We were not told, we were not informed. And then this goes into issues of, it becomes a case of unfair contracts, and it becomes an issue of consumer protection. So if arbitration and ADR is intended to be the mechanism for resolving a dispute, especially with local communities, then this should be clearly signposted. It's not just for it to be in the document. It should actually be explained to the local communities. They should be aware of what arbitration means, how it will be used, and they should be aware of their rights and privileges when under arbitration rules and norms generally. I don't want to talk too much so that we can have an interactive discussion. So the last point I will also make is that business and human rights is an area that involves a complex mix of commercial principles as well as human rights principles. Many commercial lawyers are trained in the business part, but the human rights part, especially when you talk about ESG reporting, climate change evaluation of damages relating to climate change, relating to energy transition. These are indeed areas that I hope to see more capacity building on that. And I hope to see businesses engaging with experts in this area. So perhaps it might be good to strengthen capacity in this area. And that's why I really, really want to commend the work that the center is doing, led by Professor Onyema, to enhance awareness and capacity building in this area. And so it is important for companies when dealing with these issues to engage with very, very competent arbitrators and expert witnesses that can help them navigate this sort of increasingly complex set of disputes that I've raised, that are emerging as a result of the energy transition and the rapid development of business and human rights legislation across the world. Thank you very much.
Thank you so much, Professor. That was a very interesting, topical, and timely presentation. Really appreciate it. I'll kick off with one question, and then hopefully we can open up to the floor. And if people want to raise hands or just come off mute and sort of give a question, that would be great to continue the discussion. Just picking up on sort of the last thing you said and the very first thing you said, which is arbitration is not just for lawyers. I'm talking about capacity building in the space of human rights and other types of expertise. Are there other things that arbitration itself as a institution, a global institution, needs to do to adapt to allow climate change related, energy transition related, and all of these sorts of types of disputes that we're seeing in the future? Is there anything that the institutions themselves can be doing to, rather than focusing on the businesses or the states, the users of the system, are there other things the system itself can be doing other than teaching their arbitrators more about human rights and environmental issues to make the system more attractive in the context of these disputes?
Yes, it's a great question, Hafsa. And I think one of the things I increasingly struggle with, and I know at times when I mention this, some say, well, you are one of them, those that, that arbitration is increasingly becoming elitist, right? We say that the problem with litigation might be the cost, might be the delays, might be, and then it pains me when I see these patterns being created in arbitration. I was quite optimistic in the beginning that arbitration should be the accessible mechanism that people can use and rely upon to resolve their disputes in a very confidential, confident way that they would get a remedy. So I think the arbitration institutions must look at how to increase access to arbitration itself. And that could mean many things. It could mean, rather than me every Friday, most Fridays when I'm in the airport, not every Friday, but most Fridays when I'm in the airport, rather than me seeing Nigerian lawyers flying to London to resolve Nigerian cases, I wonder why Nigerian lawyers cannot be in Nigerian arbitral institutions to resolve those cases. So expanding access to strengthening the capacity of our domestic arbitration institutions to play a big role in the resolution of disputes resulting from Africa. For example, many of the transition minerals that are being contested across the world are from Africa, right? You have, whether you're talking about lithium or you're talking about copper or gold, these are all sourced from Africa, and then their production, their sourcing, their disputes relating to modern slavery, child labor, there are disputes relating to even access of local communities to the resources, lack of transparent impact benefit agreements. These are disputes that arbitration can play a lead role in resolving. But the moment you then expect local communities to fly with you to London to resolve these disputes, then you are already creating that barrier that I was talking about. So there is indeed a need, number one, for arbitration institutions at home to strengthen their capacity in this area, to work with, to ensure that they are at the forefront of providing this recourse through arbitration. Then number two, there is a need for us that are from countries where these resources are based to believe in our own system, and to be ready to strengthen our own systems. If you really do not want all the disputes to be resolved elsewhere, then you could include that in your, it starts with the contract, right? So we need to believe in our own systems to strengthen them. Governments will also need to invest in infrastructure to ensure that when we then make use of our institutions locally, that they are indeed ready. And there are many other issues of judicial intervention, whereby, arbitration is being subjected to, judicial interference, will often scare people away. So there's a lot, and that's why we have written a book on this. But I think there's a future for African arbitral institutions. there's a future for us to then strengthen them. And lastly, there is a need for stakeholders worldwide to also ensure that arbitration reflects the contemporary reality. I was saying at the ILA conference just last week that, with AFTA, the African Continental Trade Agreement, it simply means that it's now a misnomer for African disputes to be resolved without Africans. So if there are arbitral cases that are Africa-centered and Africa-related, and then they are handled by non-Africans, it should raise big questions to any right-thinking person.
That's a very fulsome and helpful answer. And unfortunately, we don't have, a book length amount of time to go into the details of all of it. But you say some very salient things that I'm sure everyone will be thinking about after the call. I don't know if Amelia's come on because she has a question potentially, or if we are handing over to the broader group to ask any questions. If not, I have a repository of many more questions that I can ask.
I'm trying to save you the stress, but if you don't have any hands up, I'm quite happy to ask.
We have a hand.
We have a hand. I'm going to wait my turn.
Brilliant. Okay. Well, Mark, would you like to go first?
Thank you so much, Ms. Zayyan. Professor Mnyama, sorry, I put my hand up after you, so you can go first. All right, that's fine. Thank you so much once again, Ms. Zayyan. Thank you so much, Professor Olawuyi, for that senior advocate, for that very informative presentation, particularly for those of us, if I speak for myself, who might not be too familiar with this area. I've learned quite a bit from your very informative presentation today. I just wanted to ask one simple question. I don't know whether it might be far-fetched or, but I just thought I'd ask, just in the event you'd be able to enlighten me on this, is in relation to arbitral disputes in this area, from your experience, both, in practice and in research, is it a case that they're mostly investment arbitration disputes, primarily because they involve the state? I'm assuming, would that be a correct assumption, or would you say that there's more of a balance between, disputes that are commercial arbitration related or commercial in nature vis-a-vis those that are investment disputes? Is there a balance between the two? And just building on that, in your last point, where you're talking about some of the present issues we begin to see within arbitration, whereby arbitration was once sold as a process that would be efficient, that would be quick, that would not be costly. And in modern times, we're beginning to see that the opposite seems to be playing out. In terms of arbitral disputes in this sector, would you say that they tend to be honored by the parties that that the award is issued against predominantly? Would you say that they tend to be honored, or is there a case where there's a lot of challenges either within the system or before national courts that tends to prolong the proper resolution of these disputes? Thanks.
Great. So should I answer that, or are you going to gather? Okay, I should go ahead. Okay. Well, it's a great question, Mark. I think the first question, on whether on the sort of dispute, are they investor state or are they mainly non-commercial? The classic cases or disputes we've seen are mainly investor state arbitration type of situation, in which you already have the license and you are challenging a new legislation or a government action that you think affects the viability of your license. That will constitute a bulk of the cases that we've seen. But then there is now a growing trend of cases whereby maybe the state is trying to enforce legislation by maybe saying an investor is in breach of their obligation under a contract. So greenwashing, for example, our contract says you will comply with all applicable laws, and our contract says if there is a dispute, we'll go to arbitration. We are challenging that you have not complied with all applicable laws because of greenwashing or because of environmental degradation, and the likes. Those are fewer. They are fewer for obvious reasons, because the interest of the state most times in many countries that have been involved is for production to go on. So it's often rare for a state to be the one to go to arbitration to challenge an investor for, greenwashing. But this happens when the state itself is facing increased pressure from NGOs. When there is, in the news is everywhere, government turns a blind eye to the activities of, and that can lead the state to then say, okay, what are you doing with respect to this allegation of child labor or modern slavery? For example, we've seen a number of those questions raised with Chinese investments in mining across Africa. And we've seen I've been involved in a number of issues relating to that. So it's mostly investors taking advantage of arbitration to resolve their disputes, but at times with pressure, government could also be at the center of this sort of dispute. And we are even saying that arbitration should play a crucial role, especially to resolve issues relating to investors not meeting up with their expectation under impact benefit agreements, which are often negotiated with local communities, that this is how this project will benefit you. So if the project is not benefiting them, then local communities should be able to use arbitration. After all, an impact benefit agreement is an agreement, and it could include an arbitration clause, which could enable local communities to actually, and impact benefit agreements are normally agreements between an investor and local communities. That's what they have always been, and they are often a requirement for you to get the license, especially when I was practicing in Canada. Before you can have any mining or oil and gas deal or license, you must show the government that you have signed an impact benefit agreement, with the local communities. So why is it then that some of these impact benefit agreements do not contain an arbitration clause? That's a big problem. That's a big gap in my view. Now, I don't know if I don't know if I've answered your second question, or maybe if you can remind me, please.
It was on honoring awards and whether they're being challenged.
Yes.
Just can I add one other thing, which you do often see in these contexts, is post M&A disputes, because you'll have the issue with the state, and then you'll have the asset being sold, and so you might have a commercial dispute which arises out of, this is what I've seen in sort of my experience, which arises out of something which is to do with a state action where you might have some kind of claim against the state, but you also then have a follow-on post M&A dispute where the purchaser of the asset is saying, oh, well, you lied to me about this because I didn't know that the state was doing this, or that there was a security issue, or that there was these local communities who are, you didn't tell me that. So there is like a whole potential area of fertile ground for dispute when you have post M&A issues. But anyway, sorry, I just thought I would add that from my experience. But I think the second question was about whether these awards tend to be honored or challenged.
Thank you very much. I mean, and of course, thanks, Hafsa, for adding the M&A point. It's really, really crucial as well. In terms of honoring, and I hope Hafsa can add some thought on this as well. I mean, the way we see it is that, and I've been involved in trainings with the judiciary in many parts of the world on what arbitration means and what they should and they should not do, please. And that will include, we do not want judicial interference, with an award that has been rightly given based on contract, and I think that is yielding result. We're seeing the case of judicial interference being significantly reduced in many parts of the world. The whole idea of arbitration, or the strength of arbitration, is its finality. The fact that once there is an award, it is final, it is binding, it is respected by all parties. So if we have the judiciary understanding that, it's a plus. And number two, if we have our arbitration our colleagues, especially arbitral panels and tribunals, understanding the need to ensure that they have awards that are, clear, legitimate, formal and without errors, that will also be great. And that's a point that I'm involved in trainings, especially fellowship trainings for arbitrators. And I always emphasize that the success or failure of arbitration starts with them. Because if you, we've seen some, very shocking cases of awards not being well drafted or just leaving room for ambiguity and challenge, and that erodes we've also seen issues of conflict of interest whereby, and this all erode the legitimacy of the institution of arbitration. So we do hope all stakeholders will continue to play their own part, especially capacity building will be key as well, ensuring that we preserve the sanctity of the institution of arbitration.
Thank you so much. They're all really interesting, fascinating topics that I think, I would love to sort of have a separate sit down with you for a couple of days and just pick your brains. But we have other questions. I think Dio had a question, and then I think Ogatuase, or is it Victor potentially? I'm not sure which way around it is, sorry, has also raised a hand. So perhaps Dio could go first, because I think that they had a hand up first.
Hi, good morning, or is it good afternoon? Thanks for a very interesting lecture and talk. I was just wondering, when you were talking about arbitration and in its relation to decommissioning, would you consider that arbitration can be truly effective when you're dealing with decommissioning issues, especially residual liability issues? Because at the end of the day, the state has ultimate responsibility. If the licensee, original licensee or transferee or everybody disappears or goes bankrupt, then somebody has to pay for this cost. So do you think that, arbitration can play a more effective role, or should the state regulate a bit more robustly on this point? Thank you.
Great. I mean, that's another interesting question. Can arbitration play a more effective role in decommissioning dispute? I would think yes, because if there is a dispute on who has the obligation or responsibility for decommissioning, then it goes back to the decommissioning plan that was submitted. It goes back to the contract. And these are issues that could be litigated. And if something can be litigated, then you can argue that perhaps, then there's room for ADR, knowing ADR to be, and given the advantages of ADR that we've mentioned, then there's room for all ADR mechanisms to be deployed to resolve that same issue. And we've seen questions of decommissioning being litigated many times. And it often goes this way. You have a license, then you farmed out the license using a farm out contract. And now, or you transfer the license outright. As you've mentioned, the interest of the state is that the commissioning happens. So if one of the parties is then saying, I'm actually not the one responsible for the commissioning, the farm out contract only said I would do this and this, it did not talk about the commissioning, then it becomes a dispute, right? And I think arbitration could be the most effective way to resolve such disputes, because if in the farm out agreement you have included clearly the responsibility or obligation, and you have included that, well, if there is any dispute which we will use arbitration, then I think arbitration will then be useful. And the reason why arbitration will be crucial if it is included in such a contract is that it saves everyone the stress and the time. It also, reduces the need for states to be the one to be wielding the big stick on this issue. So I think it's all about specificity, being specific when transferring or amending the terms of a license, when drafting agreements related to that. I think if we do that, then we will see a clear role for arbitration in resolving these disputes effectively.
Thank you so much, Professor. Can I pass over now, possibly to Ogatuase?
All right. Thank you very much for this opportunity. Thank you, sir, for the insightful session so far. Yeah, so my question borders on the first pillar of the United Nations, that's UNGP, that is bordering about state duty to protect human rights. So in Nigeria, the environmental objectives, that in Section 20 of our Constitution, they are non-justiciable, and from court decision from judicial precedent and some cases that has been held that environmental pollution poses a risk to rights to life. Yes, so far the environmental objectives are non-justiciable. That poses like a barrier to to achieving the or implementing the first pillar of the UNGP, which is state duty to protect human rights. So, sir, what do you think is the way forward? Because so far environmental objectives are non justiciable, then our environment, that's where we live in. Yes, has a lot to do with our life, which also affect our right to life. So, sir, what do you think is the way forward now?
Well, it's a great question. And there are many ways to answer that question. The first point that could be made is that over the years, we know that that provision of the Constitution has been a problem because it says you have a right to a clean environment, but it then says, these issues, these matters, including that provision, you can't really enforce it in court. So we say, well, what is the point? But I should say that there have been recent cases that suggest that that section is justiciable. If you look at, for example, the Center for Air Pollution Watch versus NNPC, I think it was stated clearly by the court that that provision is now justiciable. So that gives some hope that that cloak of non-justiciability has been removed by that court. So that is promising. But I think a much more promising intervention by the state will be to also now clarify that in legislation and in constitutional amendments. And that's where our advocacy has focused upon. We've been mentioning that because the fact that one court said that, especially if it was not the Supreme Court that said that, means another court can say, well, I don't agree. So that is why we think there should be a clear mention of the justiciability of that provision in ongoing constitutional reforms and amendments. Number two, it should be reflected in our legislation, in our national action plan, as well as there should be a clear business and human rights legislation that includes that clause, again, that shows that if there is a problem, and if my right to a clean, healthy, and sustainable environment has been impacted, I can indeed go to court. So we cannot continue to rely on the mood of the court on these questions. So I think that is why, often when we interact with the government of Nigeria, we often say that that state duty to protect will include clarifying that environmental rights are indeed justiciable.
Let's hope that that's the way that it goes, and hopefully people in government are listening to this conversation and take up what you've said, Professor. I'm not sure if we have time for one last question. I defer to Amelia on that topic. I do see there is one hand up, one final hand, so perhaps we can round off with the final question, if that is okay. I'm getting a thumbs up. Brilliant. Raoul, please, can I hand over to you if you'd like to ask Professor Damilola the question?
Yes, thank you, Professor. I just would like to come back to your answer to Mark's personal questions, where you mentioned local communities. How is it possible to integrate local communities in an arbitration agreement, because I don't think they have a different legal personality from states. So I don't know how does it works to integrate local communities in a arbitration agreement, because usually this arbitration agreement is linked to the original contract. So I don't know how we can add them or integrate them in a arbitration agreement. I don't know if I didn't understand what you said about it.
Thank you very much. It's a great question. And this is why this is a subject that is quite, this question is quite unique to energy and mining transactions, because due to concerns over the years that local communities are not involved in mining agreements, they just hear that there is a new license that has been issued. International law began to recognize the idea of free prior informed consent, FPIC, which says local communities should actually be involved, be carried along in the process of issuing licenses. Their opinion should be sought, should be freely given, should be prior, should be informed, and they should give a consent before government will go ahead to issue licenses. So that's part of international law. And the implementation of that FPIC is why some countries now said, well, before you come to us for a license, before you come to us for a production sharing contract, show us your impact benefit agreement. I was part of the team that drafted the new mining law in Nigeria. And we included a provision there that before you can get a mining license, you must have an agreement, an impact benefit agreement with local communities. And that is in line with the practice in Canada and in many other jurisdictions, in Australia, in New Zealand, where in order to resolve this issue of we're not carried along, you would have an impact benefit agreement. And it is part of the law. It is in that agreement that we hope that you can then say, in case of any dispute relating to whether the community is benefiting, whether the community is feeling carried along, then you should include an ADR clause in that impact benefit agreement. So that could be, in my view, a very good mechanism, to introduce ADR in the context of mining, given that from what I've described, it simply means no one can get a license without an impact benefit agreement. So why don't you include ADR as a mechanism for resolving disputes relating to whether the local communities feel that their lands have been grabbed without due process, whether they feel that their lands have been polluted, there's no water. All of that are part of impact, lack of positive impact of the project, and should be will be a good way for arbitration and ADR mechanisms to really come in, such that the local communities can get a speedy resolution for their concerns, and by so doing, Pillar 3 on access to remedy would have been fulfilled by the state.
Do you typically see a court? What's the dispute resolution clause that you typically see in those types of agreements? Not arbitration.
Unfortunately, we still see the gap that there is no mention of arbitration. It's often it's often maybe the highest you can see is maybe negotiation. In case that you're not satisfied, then we will make efforts to resolve this in 30 days or and we all know the challenges related to that.
Agreements to agree. The best things ever. Well, thank you so much. Can't thank you enough. Thank you everyone who joined. I will hand back over to Amila to sort of round everything up and close off. But many thanks on my behalf, and especially to you, Professor, for the wonderful insight you gave, and SOAS and Amelia and the whole team at SOAS for hosting this really timely presentation and lecture.
Thank you, Prof. Thank you, Hafsa. This has been an excellent use of our bank holiday early afternoon. Prof, you have to come back so that we can have a fuller conversation around local communities and their engagement, because as you know, that's something I am currently also looking into and working on. And one of the things, the other side with local communities, of course, is who is the local community? Who is the legitimate representative of the local communities, and how engaged are the local communities, because when you look at the discourse from Southern American countries and African countries, it's really very different. Very different. And the role of public interest litigators as well. And as you rightly mentioned, jurisdiction. So it raises a whole lot of other questions, which Hafsa would agree that another webinar should begin to unpack some of those issues. And one of the other reasons why we hold these webinars and try to engage with substantive international law issues is so that people can begin to think around new areas of research, new areas of putting up new papers and engagements, and thinking through carefully what should we be discussing, what should we be engaging with. Prof, all the people in the webinar have said, oh, we have people from New York City. Aren't we lucky that they woke up really early? I told you, Prof, that your name will just make sure we have enough people to attend. You and Hafsa, thank you so very much. We're very grateful. And this brings our webinar to an end. So, Prof, you need to give us a new date for something else that would really focus on local communities. And Hafsa, you need to begin to think around M&A, what you're seeing in your practice, so that so we have 2 webinars coming out of this, and this is how we grab people. So thank you so very, very much. Prof, we're so very grateful. Thank you. Thank you, everybody.
Thank you so much. Thank you, Prof, and thanks to SOAS Arbitration and Dispute Resolution Center. It's been a great pleasure. And thanks to Hafsa for the wonderful moderation. Thank you so much.
Thank you, everybody. Bye.
Thank you. Bye.
Thank you.